continue to gather data and do everything that we can so that parents, qualified parents, parents that deserve equal shared time with their child will be granted that. So with that, I think we have the champion of the bill, the author of the bill as well, Chad, that will speak first at the press conference.
All right, thank you. My name is Chad Loudermilk, and I'm the president and co-founder of Illinois Fathers for Equality. As a parent of divorce, we decided to form the organization in Southern Illinois and drastically saw the need for parents wanting equal time with their kids. And so we stood up and we wanted our voices to be heard. And so this is what we're here for today, is we're trying to get a 50-50 presumption bill passed in the state of Illinois to help our children get out of the negative parts of being from a single-parent home. We know that children from single-parent homes are more likely to drop out of school, have higher suicide rates, are likely to abuse drugs and alcohol, higher teen pregnancy. What our bill is proposing is that we're involving both parents into those children's lives, and research shows that it drastically reduces those risks for those children. And so this bill is for our children of Illinois, and we hope that everyone supports this bill. When it comes to time to vote. Thank you.
And Jeffrey Levin is also here, a supporter of the bill and a father's right advocate and a family law attorney.
It's an honor to be here. This is a great bill. It's a fantastic House bill. It's really important because each child in the state of Illinois should have two parents, two loving parents. A presumption of equal parenting time for both parents is fantastic. It's only a presumption. A judge can change it, can be rebutted. But it's a great way to start out any family law case, so every family law case in the state of Illinois will hopefully start out in a non-adversarial manner in an adversarial system. And it's very difficult because this type of change is going to be difficult to embrace in our judicial system because it is an adversarial system. I'm a lawyer. I exist in an adversarial system. But when you're dealing with families and the futures of children, it's really important that we have a presumption that there should be equal parenting time for both parents because both parents are important. And this should significantly reduce litigation, which could only save children's lives. I worked on a terrible case where I represented a dad recently. I believe he was falsely accused of abuse. We fought long hours, days, weeks, months, to finally reconnect him with his children. And I was so happy when we reconnected him with his children, but he went through so much stress fighting for his children that he passed away. Had a heart attack, the stress killed him. It's just really sad. And I think with this type of presumption, maybe this dad, maybe his children, maybe the mother, maybe the whole family would not have gotten thrown into such an adversarial, highly litigated case if everybody started out on the same page where both parents were presumed to be good parents, where equal parenting time was presumed to be in the best interest of the children. So I hope to God this becomes law. It's a great bill. Thank you.
Judges to pray.
And thank you. It's an honor to be here. Thank you.
Thank you. From dads.
Hi, I'm Jesse West Sr., Dad's Care 2 out of Springfield, Illinois. I'm president and founder. I started back in the beginning of 2016, working for changing laws, bringing the community and state together for equal shared parenting. I knew it was going to take an army. We got partnered up with other organizations, Illinois Fathers for Equality, Chad and Corey, as soon as they got started, and other organizations all across the nation for equality. bring the best interest to the children is our main focus, and we're going to do everything possible we can to pass this House Bill 4113.
My name is Cash Jackson. I'm a retired Navy veteran. I'm also a 2018 gubernatorial candidate for the Libertarian Party here in the state of Illinois. I came down to support the 50-50 parenting bill because underneath the Constitution, we do have, while not explicitly spelled out, we do have an implied right as fathers and as mothers to raise our children absent the interference of the state. If the state has not proved that a parent is unfit by a clear and convincing standard, which is what it should be, then they have no business in interfering. This is obviously an emotional issue for moms, for dads, for grandparents that don't get the access to their children. We have a duty and a responsibility to future generations, to our current children here now, that we protect their equal access to their mom and their dad. Make no mistake about it. It's not just dads being affected. You have people like my friend Joe Ellen. A friend of mine, Shannon Baskins, passed away 2 days ago. Caught up in the system for 5 years. A young mom, 35 years old, passed away. Tom Doheny in McHenry County, incarcerated for 3 weeks, killed himself after he could not afford $20,000 a month in child support. The only way to justify child support orders is to justify making a parent a visitor to their children. That's it. But if you have a mom who's there and she wants to raise her kids, like my friend Gwendolyn Chubb here in Chicago, who has fought for over 7 years to be a mother to her children, this isn't just affecting dads. This is affecting moms, and ultimately it's our children that are suffering. We have a duty and a responsibility right now to honor and protect the Constitution and to protect our children and all future generations. I appreciate Representative LaShawn Ford, Illinois Fathers for Equality. They've done an amazing job, and I look for this bill to be passed.
Thank you. 2 more speakers.
Hi, I'm Dr. Jim Bedell, a psychologist kind of coming from the mental health perspective. The reality is, the research indicates that the best interest of a child is served through consistent contact with both parents in an equal fashion. But that is the factor that kind of trumps every other element that may be looked at, whether it's conflict between the couple or anything else. It's that bond and that connected relationship between the father and the child and the parent and the child. And that the reality is children have a right to their parents have a right to their children. The court should not intrude in that process. They should not divorce children from their parents. And we're trying to get a social justice change that gets away from these violations, I think, of the rights of both individuals involved. So that's my concern.
State your name and where you're from, and introduce your blog.
Hi, my name is Vito Glazers. I'm from Chicago. This is my son, Vito Jr. And I just recently received joint custody of my son, which at the time, I was under the impression, which probably most parents who receive joint custody, the impression they get is that, the responsibilities will be shared. But what most parents don't understand, and what most people, the public is really deceived by, is that joint custody really only entitles you to maybe 1 day a week and every other weekend. I heard some of the arguments against this bill being passed saying that, oh, well, what's a child going to do? Is he going to spend 1 week with one parent and 1 week with the other and not see the parent for a whole week? Well, that's the case for most parents with joint custody. I go 2 entire weeks out of every month without having any contact or connection with my son here. And he asked me often, he says, why don't you see me more? And how am I supposed to tell this child that I want to see him every day if I can? So if this bill, when this bill hopefully is passed, the joint custody doesn't have to be a child taking a suitcase to school twice a week like some of the opponents present that argument. It could be as simple as, just having the opportunity to have one more dinner with my son during that week, or being able to take him to school one morning. Just any ability to interact with him more than what the current order allows. And I want to be more than just a visitor. I want to be more than just a playmate. I want to be a father. And to do that, I have to have a consistent ability to access my child and to be highly involved in his life. And what the current system really allows is just for a vengeful parent to be able to alienate the child. And what we need to do is really correct that. And I hope that by supporting HB 4113, and I hope that by getting this bill passed and with the help of State Rep LaShawn Ford, and I really appreciate you for putting your neck out because I know sponsoring this bill might not make you popular in Springfield, but it really is in the best interest of the children to have both of their parents in their lives if the parents are able and willing and want to be there. This bill isn't about the parents who don't pay child support or who don't want to be in their kids' lives. This is about giving access to parents who want to be involved in their kids' lives and empowering to do that. And I thank you very much for responding. Thank you. Yes, my name is Vito. That's spelled V-I-T-O. My last name is Glazers, Glazers, and I'm a father here in Chicago.
And Juan, and Jeffrey Levy is going to close out.
Hi, my name is Juan Carlos Felipe. I'm resident of Illinois, Fathers here in Chicago. I just wanted to add really quick, we should not stop sacrificing ourselves after a separation of a divorce. If we are able to just respect each other, communicate with each other, and keep in mind that it's not about the adults, it's about the children. It's how much they're going to miss if they see the other good parent. Mainly, that's the message that I want to get through. I thank you very much for all being here. Thank you very much. And all you came together. Thank you.
Again, Attorney Jeffrey Levy. I'm a matrimonial lawyer in Chicago. I also chair the Illinois Council on Responsible Fatherhood. I have the pleasure of our governor, the governor of the state of Illinois, Governor Rauner. It's an honor to be here, I'm a proponent of this bill. As Charles Darwin once said, that the survival of any species is not based on strength, intelligence at all. It's based on adaptability to change. And change is very painful. Change is hard to confront. Change is very difficult to occur in our legal system, in our judicial system, because it's change. But change is necessary to protect Illinois families, children, fathers, mothers. Change is critical. This House bill is an important part of that needed change, and I believe it will be painful because change is difficult to embrace, but it's necessary for our future and our survival, and I really believe it will happen, and this will become the law, or something close to it, because it has to happen, because Illinois families are depending on things like this and this type of needed change. Thank you.
Thank you, and thank you, Gary. Thank you, WB. And this concludes. Now that you have questions.
Maximum time is very ambiguous. Different people can differ on what the definition of maximum time is, but nobody can differ on what the definition of equal parenting time is. It's sort of like the old argument, we should have reasonable visitation, but what does reasonable visitation mean? If there's ever an issue in court where a court has to decide whether visitation, what is now called parenting time, is not working, or a contempt order should be entered, if it's reasonable, a judge will have difficulty making that decision, because who knows what reasonable means? It's specific. Maximum is an ambiguity. Equal is a defined term, and we don't know what that means.
Jeffrey, don't you also agree that despite the ambiguity and the fact that there's not a specific schedule written, there seems to be a close denominator in Illinois regarding what kind of schedule is going to be issued by a court, and that's why people understand the concept of standard visitation.
I agree with you. You're making an excellent point. But the key here is there's all types of unwritten presumptions. There's a lot of guesswork. What we need is more than just guesswork and unwritten presumptions. Courts really need to know that the law specifically states that equal parenting time is in the best interest of the children. Obviously, it can be rebutted. There's a situation where there's domestic violence, false abuse allegations, it just is not workable, then equal parenting time should not occur. But it's critical that every case start out with both parents on equal footing, because that will help courts make decisions and it will reduce conflict. It's Very, very important.
And what type of law what type of society do we have when people go into the court knowing that they're not equal, with an equal shot at success? So the way the law is today, it's clear that sometimes parents have an advantage over us. And we can't have laws in Illinois that puts anyone over another when both are possibly capable parents. So our laws must see each parent equal and see them for who they are and not who the judge's discretion say that they are. But they must take a look at the person in its entirety. So today's meeting, I think it was pretty valuable to have a roundtable to get all of the stakeholders together. You know, just to get to know one another so that we can continue the discussion. We have people coming from rural Illinois up to Chicago in order to fight for the change in Illinois' law. And people have a right to change the law in Illinois if they feel that it's not working in their best interest. And so today, I believe that government is open to the people so that if they see change necessary, they should have a right to advocate for that. This is a state building. They have a right to a meeting. They have a right to state their claim. And that's what this meeting is about, giving everyone an opportunity to come to a compromise and do what's in the best interest of children and families.
Actually, why don't Jim Hadler, do you want to explain? Jim Hadler is a fantastic matrimonial lawyer. For one thing, the representative board said it's critical. Equal process, equal protection, due process. Everybody in this country is entitled to equal protection. It doesn't matter what your race is, your gender, your religion, your national origin. That's what Jim Hadler is going to do right now.
The law was recently amended, and the current status is that the law presumes the maximum involvement of both parents. But the reality is that doesn't mean equal parenting time to start off. I believe, I'm a matrimonial attorney, I've worked with Mr. Levin 25 years. I see a lot of parents that would love to see this law because they'll say, wow, this is what we should start with. This will diffuse a lot of litigation. It will make people want to come and work together. That's my opinion, and I've seen it increasing all the time. Now, there's a lot more parents that want 50-50. True, they have to reside reasonably close together. But that's what parents, if they really want to be involved with their children, that's
Gary,
what they're going to do.
is that answering your question? That doesn't answer your question. Why are we attempting to change the law today?
What is the current law? I think I got it from the meeting. Thank you all for your time. Yeah, I'm good.
Okay, current law, like he had stated about the best interest, the current law also goes into using a burden of proof as preponderance of evidence. Also the current law does not have in the statute and in the law that judges need to put in writing why they ruled certain ways in the courts. What our bill does is it changes the burden of proof from preponderance, which is current law, to now what we're asking for is clear and convincing, which is a higher burden of proof. And that's because we feel like as a parent, there needs to be clear evidence to take our rights away as a parent. Good parents are getting those rights stripped from them by a preponderance, and they are good parents, and that's suffering that's detrimental to our children. Right now, a judge can rule any way they want, and they don't have to state why they ruled the way they did. What we're asking for is that a judge puts in written findings as to why they deviated from, say, 50-50, what we're currently asking for. So we're asking to do that so we as a parent can know why a judge took away our parenting time, so maybe we can rehabilitate ourselves, so we can do what needs to be done, so we can be active in our kids' lives. And that's all we want to do here is that the current law has flaws in it. We know that. We have research that backs that up. And so what we're putting into this bill changes that so where it supports more of a shared parenting, equal parenting time, and what's best for our children.
The short answer really is currently one parent gets 1 day a week and every other weekend, and the other parent gets 20 days a month with the child. And if the other parents, if the non-custodial parent schedule allows and they are interested, they should each have the ability to see their child equally. That's the bottom line.
Ask another question. Are there any
Yes, there is. There is a national organization called Leading Women for Shared Parenting, and they're a national organization of women that support shared parenting. They have, from my understanding, support this bill. They have been to other meetings with us and other conferences and stuff. They support it. Actually, our organization is about 2,900 people all in the state of Illinois. And as of last night, we have about 30% of those are women. So our organization is women as well. We have, grandmothers, mothers, stepmothers that all support what we're doing here.
Thank you, Carrie, and thank you all for being here.